Vamos a ver la conferencia Current State of U.S. Antitrust Law Informants por Krisztian Katona, Vicepresidente de Competencia y Política Regulatoria de la CCIA, Computer and Communication Industry Association. ¿Quién no pudo venir en esta ocasión? Vamos a mirar la conferencia.
Good morning and muy buenos días a todos. First of all, I would like to express my thanks for the invitation to speak at the 8th annual ACDC conference. In these last 8 years, this is the 4th time that I'm participating in this event, and I'm really sorry that due to a last-minute issue, I can't be there in Medellin in person as previously planned. Now, looking back at these 8 years, I would also like to take a moment and congratulate ACDC and both its previous and current leadership for having the vision to convene such an inspiring and highly substantive program that really has become a leading annual event in Latin American and international antitrust. So, congratulations to Felipe, the entire ACDC board, and everyone who has been involved in building the association to what it is today. It really is my honor to provide today an overview of the current state of US antitrust enforcement and policy and discuss some important recent developments. I've been practicing antitrust and competition law in the United States and internationally for almost 20 years now, and I would say that today's upheaval in US antitrust thinking and enforcement scrutiny might only be comparable to that of the 1960s and 1970s when the US government focused on several major investigations against petroleum refiners, IBM, AT&T, and so on. And what we are seeing now today is major monopolization cases being brought by the US federal agencies, the FTC and DOJ. We also see that DOJ continues to be very active in cartel enforcement. The FTC and DOJ also have a very robust merger control agenda with major merger policy initiatives in addition to increased enforcement efforts. And we also see US states playing an increasingly important role in antitrust enforcement and policy. And if we take a snapshot of where we are, we should also keep in mind that in less than 2 months, there will be presidential elections in the United States. As such, I would like to provide an overview of some of the key developments and discuss where we are in the US in 3 main substantive antitrust areas, and those are single firm conduct, cartel enforcement, and merger control. In addition, I think it is important to briefly discuss what we might expect in competition policy and enforcement with the upcoming elections. I will first talk about single firm conduct, as the agency's monopolization investigations have often been the headline news for the last couple of years. A number of these cases have been focusing on practices and companies in digital or connected markets. There is a collection of cases here, so I would like to briefly go through where we are on these. Many of you have been closely following the Google search case. In addition to Google search, there is also the DOJ case against Google's EdTech business, which is currently being litigated. The FTC has brought a monopolization lawsuit against Amazon. And there's also the DOJ case against Apple. In addition, just earlier this week, DOJ filed a monopolization lawsuit against Visa. Many of you might have seen that update as well. Among these cases, I will start with the Google search case. So DOJ filed this lawsuit during the previous administration in 2020. And just last month, in August, US District Court Judge Mehta ruled that Google had engaged in anti-competitive practices by entering into distribution agreements that established Google Search as the default search engine for third-party web browsers and mobile devices. According to Judge Mehta, Google's conduct allowed the company to illegally maintain its monopoly power over the search engine market. On the other hand, other important elements in the judge's analysis of the case include really his acknowledgement that consumers choose Google search because it provides the best service for them, then how being a monopolist is not per se illegal, and how Google obtained its market position through significant investment and legal methods of competition. The case is still pending the determination of the remedies, which will likely be resolved next year by August 2025. And the remedies could range from prohibiting Google from entering into these agreements to forcing the company to divest some of its business. Last year, the DOJ filed another lawsuit against Google, this time focusing on its digital advertising technologies business and alleging that the company monopolized digital ad tech products. According to the DOJ complaint, Google prevented other companies from building scale by using its ad tech stack to self preference. And this case will also provide an important discussion around how the relevant market should be defined in these two-sided or multi-sided markets with both buyers and sellers interacting in a platform. Now, the trial phase of this case began just a few weeks ago, earlier this month, I think on September 9th, and it's still ongoing. So keep an eye out for developments in this case in the coming weeks. Now, besides these two Google cases, earlier this year, the DOJ filed a monopolization lawsuit against Apple following a 4-year investigation. As to where this case stands, in August, Apple filed its motion to dismiss, where it argued that DOJ's case falls short of proving the three requirements the court needs to consider to determine a monopolization claim. First, a monopoly power, then anti-competitive conduct, and anti-competitive effects. Regarding next steps, the judge will hear oral arguments on the motion to dismiss and will determine if the DOJ's case is strong enough to move to trial. Now, the FTC, like the DOJ, has also been active in pursuing monopolization cases against companies in digital markets. Back in September 2023, the FTC and several state attorneys general filed a lawsuit against Amazon, alleging anti-competitive practices in two relevant markets, and those are online superstores and online marketplace services. Among others, the key issue in this case will be the FTC's market definitions, which, as commentators have also noted, don't seem to take into account the robust competition between online and offline retail, and also the omnichannel market dynamics in this space. This case will head to trial probably next year. Now, in addition to digital markets, in recent years, the agency's active Section 2 enforcement agenda included investigations in healthcare and other industries as well, including the FTC case against health information companies SureScripts. Finally, the most recent monopolization case filed by the DOJ this week is the civil antitrust lawsuit against Visa for monopolization in the debit network services. And this DOJ complaint comes following a 3-year-long investigation that began in 2021 after the DOJ blocked Visa's intended acquisition of Plaid. So, what one can see on all these monopolization cases is the US enforcement agency's broad push on Sherman Act Section 2 enforcement. The key question is whether the agency's aggressive approach in monopolization cases will be successful in courts. And the stakes are very significant. These cases can significantly impact digital markets, the innovation ecosystem, and in that regard, the broader US economy for years to come. Following single firm conduct, I would like to turn to recent developments in US cartel enforcement. The DOJ continues to be very active in this area. In particular, there has been intense agency scrutiny over the use of algorithms in price fixing. Just last month, in August, DOJ has brought the RealPage case, the agency's first case involving the use of AI, artificial intelligence algorithms, to coordinate and monopolize markets. And in RealPage, the DOJ is alleging that a pricing algorithm violates the antitrust laws by decreasing competition among landlords in rental pricing. Now, the agencies have continued to maintain, and DOJ has mentioned it in a number of speeches. DOJ officials noted that algorithmic pricing is still price fixing. Algorithmic price fixing would still be considered type price fixing. We also see the DOJ's increased focus on compliance programs. which, as the DOJ articulated, must account for the use of algorithms and other information sharing tools. The DOJ has also released additional guidance indicating that messages sent with messaging tools, such as WhatsApp, must be preserved, and that failure to do so may be viewed as obstruction of justice. And this is in line with the DOJ's broader focus on AI related issues. Last, in cartel enforcement, and as the World Cup qualifiers are on in Latin America as well, and I assume there are many fans of Colombia's selección at the conference, I wanted to mention another important update, which is the joint initiative by the US DOJ, Mexico's COFECE, and Canada's Competition Bureau to deter, detect, and prosecute collusive schemes in connection with the upcoming 2026 FIFA World Cup. So the three agencies noted that they will use information sharing and international cooperation tools on joint investigations and public outreach initiatives to prevent and prosecute any anti competitive conduct that might occur surrounding the event. It is worth noting how this focus on cartel enforcement around a major sporting event is not necessarily new on a global stage. For example, Japan regarding the 2020 Summer Olympics and Brazil regarding the 2014 World Cup also looked very closely at potential collusion schemes in that regard. Now, after monopolization and cartel enforcement, I would like to turn to the third main area of antitrust enforcement, which is merger control. And this is an area where we have seen a dramatic expansion of the US agency's merger program over the last couple of years. So the two agencies' current leadership has noted that they view mergers with increased scrutiny. And they also consider the past couple of decades, the past 20 years of merger enforcement, to have taken a hands off approach. In addition to horizontal mergers, the US FTC and DOJ have increased their scrutiny of mergers with vertical features and also those featuring complementary products that may eventually become substitutes. Now, in addition to heightened merger enforcement, we have also seen major policy initiatives, including the 2023 merger guidelines and the proposed revision of the Hart-Scott-Rodino or HSR pre-merger notification rules. So I will briefly address those now. So the 2023 merger guidelines have been in effect now for about 10 months since last December. And the guidelines provide an expansive view of merger analysis. And unlike recent iterations of merger guidelines, for example, from 1992 and 2010, the 2023 guidelines address both horizontal and vertical mergers. Both the FTC and DOJ have been working to institutionalize the guidelines internally, really with a higher focus on structural presumptions and some new theories of harm. We have heard from top agency officials that there is a need to give additional focus to the competitive effects of mergers in areas that traditionally have been outside the review of antitrust enforcers. For example, the agencies have focused on labor markets, which has also been a key issue in the FTC's recent challenge to the proposed Kroger Albertsons grocery store merger. This case is actually also notable for being one of the first challenges filed after the 2023 merger guidelines had been adopted, and it's currently in litigation. Of course, a key question for this case and other agency challenges is how the courts will receive these theories and policy changes. What we can see is that so far, the agencies haven't been particularly successful in courts pushing these theories. Now, there has been a lot of discussion about the new merger guidelines. However, there's another initiative that I believe might have an even larger impact on merger activity in the United States, which is the proposed reform to the Hart-Scott-Rodino or HSR rule revision. And this proposal would significantly change the amount of information required in the agency's pre-merger notification filing form. And it would be the biggest change in this regard since the HSR regime was established in the US back in 1976. So the agencies estimate that these changes will increase the notification burdens of merging companies, the breadth and depth of information they have to submit as part of a filing, to 4 or 5 times on average per notification, which actually could increase sevenfold for more complex transactions. So again, this would be a huge procedural change, which would have a very significant impact on every transaction that needs to be notified in the US. And as agency leaders have noted, the HSR rule change is expected to be finalized in the coming weeks or months. Third, I also wanted to add that the US agencies have been closely looking at so called roll up strategies and serial acquisitions and potential competition issues in that regard. This actually has been a key point of the new merger guidelines as well. And the agencies just had a request for information that closed, I think, a couple of weeks ago, earlier in September, on these issues. So, for companies and their antitrust counsel, this will likely be an area to watch closely in the US. And as I see in a number of other jurisdictions, this has been a hot topic as well. In addition to these policy initiatives, we also see heightened merger enforcement by the FTC and DOJ in a number of industries. Among them, we see a particularly high level of agency scrutiny of transactions in the digital or connected technology space. For example, in fiscal year 2022, from the over 3,000 reported transactions in the US, technology or digital mergers had approximately a 20 to 33% higher rate of receiving a so called second request, which is an in depth review, than mergers in other industries. And this included transactions such as Meta Within, NVIDIA ARM, and Microsoft Activision as well. We have also seen considerable resistance from the enforcement agencies to propose settlement agreements and consent decrees. And the FTC actually hasn't agreed to a pre litigation merger remedy since October 2022. And the DOJ has not accepted one since 2021, since November 2021. So, what we see as a result is that fewer proposed deals leave the boardroom, and a number of them have also been abandoned by the merging parties. And as many commentators have pointed out, the agency's increased regulatory scrutiny can significantly chill merger activity in the US economy, which in turn could have a significant impact on the broader innovation ecosystem, including startup acquisitions as well in the US. Now, to conclude, and having gone through some of the key recent US developments in antitrust enforcement and policy, I also wanted to step back for a moment and put the current regulatory environment in perspective in light of the upcoming US presidential elections in November and see where we might go in the coming years. I mean, the only thing we know for sure is that there will be a new president in the White House following the elections. Looking back, President Biden's executive order from July 2021 laid down the so called whole of government approach to competition policy, reflecting the administration's concerns regarding overconcentration in the economy. It is yet to see whether this approach will guide antitrust policy following the elections. One thing is for sure, which is that the role of courts shaping US antitrust law and policy cannot be underestimated. Now, following the Google search decision, it is left to see how the remaining monopolization cases I discussed will be decided in the coming years. But importantly, the outcome of these cases could really very significantly impact the future direction of antitrust policy in the US. Thank you again for inviting me to deliver remarks on the current state of US antitrust enforcement and policy. I hope that I will get to see you all in person very soon. In fact, I wanted to add that the American Bar Association's biannual Antitrust in the Americas conference will take place next May in Cartagena, Colombia. And we just finalized the dates of the event, and it will be held on May 19th and 20th. And I will have the honor of chairing the ABA conference. And I also very much look forward to working with all of you on this program in the coming months, with Felipe and the ACDC leadership, with Mariana Camacho, who many of you know, and many others. And I look forward to seeing you there. Thank you again, and wishing you all a very successful 8th annual conference. Muchas gracias.